Okay, good morning, everyone. Thank you very much for being here. It's a pleasure to make this presentation because we think it's a very important presentation with regard to the use of artificial intelligence in the criminal justice system. And what we really want to point out is the use of systems to predict risks which have implications for sentencing, bail decisions, and a number of decisions that are crucial to the rights and freedoms of citizens. So my name is Carlisle. I'm Carlisle George, and my co-presenter is Uchenna Nnawuchi. So I will allow Uchenna to introduce the topic, and we will move in and out. Thank you.
Hi, everyone. It's a pleasure to be here. My name is Uchenna Nnawuchi, just like my colleague said. So we'll be talking on when AI commands the bench. We're trying to look at automation bias and the future of judicial independence, especially when some of these automated systems are being used to make recommendations or even, in fact, do give decisions. Next slide, please. Next slide. So we've seen that artificial intelligence, specifically machine learning, which is an aspect or a subset of artificial intelligence which is a subset of artificial intelligence that is trained on various amounts of data. They learn on how their environment works. They learn on various systems, and they're able to make recommendations and decisions. We've seen that they've been applied in various sectors, whether it's criminal justice, border control, in various aspects, really. While our focus here is on criminal justice, we see that they are now being used for making decisions surrounding bail or parole or sentencing, or even probation and supervision. For example, one of the most important use cases had to do with the state of Wisconsin against Loomis. So in this case, Loomis, who had applied to be granted probation by the court, was denied probation by a risk assessment algorithm called Compass. So one of the issues that came out of that decision was that Loomis did question the decision for due process of law. His case, or rather his argument, was that he was not able to understand the decision of the algorithm, why it rated him to be high risk, why the algorithm gave him a high risk of reoffending or committing the same crime again. He tried to apply to the Supreme Court to challenge the decision, and the court did say, while it warns against the use of AI systems in criminal justice, however, that the decision still stands. But then again, it still leaves the unanswered question: what does one do in such a situation like this, where an algorithm has made a decision about you, which affects your interest, which affects your liberty? How do you challenge it when we do not understand how the inner workings of this system function? So this is actually a very pivotal problem when these opaque systems are being used. The next slide. Now, we have identified some of the tools or some of the risk assessment tools that are being used today. For instance, in the UK, we have the offender assessment system, which is widely used in terms of profiling offenders, influencing bail or sentencing decision. In the last year, we've had over 250,000 persons assessed using this system. You also have the offender group reconviction scale, which is also a predictive tool used in the UK to also determine when persons are most likely to reoffend within 2 years. Again, it does bring to the fore what kind of data these systems are being trained on, and the impact it has on people. Again, we look at the harm assessment risk tool, which is being used by police in the UK to predict reoffending. And then we have just briefly talked about Compass here, which had to do with the Loomis case. So these are some of the risk assessment tools that are being used in the judicial system to influence, or rather recommend, judges on what to do in terms of maybe granting bail or probation or supervision. Next slide, please. Notwithstanding some of the issues I have raised in the previous slide, which is opacity and the bias of this system, the data that is being used. Yeah, it does have its benefits. For instance, precision. One of the benefits of AI being used in this industry is precision. We're talking about how accurate the AI results or the predictions are. So we tend to rely on this system because of how accurate these systems have been trained over time to perform a particular function. Again, we talk about efficiency. How quickly does this system do what it's being asked to do? Again, we know that these systems do employ high computational power. So then they're most likely going to be very quick at, either making some recommendation or pointing us to a certain direction, which has to do with the tasks they are being asked to perform. If you compare that to their human counterparts, you realize that it does take us some time to perform some function, but then with the AI systems, it's way easier to do that. We talk about consistency. So when we talk about consistency here, we're referring to how does this system or the ability of this system to produce similar or the same results over time? How consistent is it? If when similar inputs are being put into the system, it will produce similar results. That's what we're talking about, the consistency of AI system. Again, how robust are this system? How does it continue to function even when there's certain noise or incomplete information being imputed into the system? How robust does this system continue to work? How reliable are AI systems in this situation? Of course, when the system continue to perform consistently over a period of time, then you see how reliable they are. So these are some of the reasons why we adopt AI, or specifically machine learning, in judicial systems. The next slide, please. So, however, we take a back stroll to the issues that I did mention above, which has to do with bias and also has to do with opacity and then accuracy of the data that is being used. So, for instance, when we talk about bias, we know that an AI system is only as good as the data that is being fed into the system. So imagine a situation where we have proxies of historical data, or maybe race or geography. In fact, let's deal with proxies of historical data for a moment. Here we're looking at maybe not directly where someone is from or their race. Maybe it could be an information about one's educational level that can be used to determine if such a person, what kind of economic status the person has. Now, one would say, oh, such a data you cannot derive such information from such data, but then that is what we talk about when we look at proxies of historical data. So there are some sort of variables which may not be directly linked to the particular task which the AI is being, tasked to do, but then it has a relationship with the individual. Again, another example of proxies data which can act in that type of ways when you're looking at something. For instance, let's say when you're looking at one's employment data, this sort of history has effects on individuals. So again, another thing could be the postcode, for instance, to determine maybe the background or the community where an individual is from, or the geography. This can all play a role on the decision some of the algorithms do make. And the effects sometimes could be positive, false positives, or false negative. We talk about the accuracy, which we're looking at the veracity of the training data. So how accurate is this data? In a few minutes, my colleague will talk about a case study which we had looked at, and you see some of the complaints by the decisional subjects or the people who were currently in prison at the time, saying that the wrong data was being imputed into the system. So how accurate are the data that we are using at this time? Again, opacity. We're looking at, of course, when we say these systems are opaque, we're looking at the fact that they make use of deep neural networks, which do have black box effects. The effects we try to find out, or we see from the use of this system, is that they tend to protect trade secrets. For instance, commercial companies who make use of this system do not want us to open the black box to know how some of this algorithm works or how some of these decisions were reached. So they are protected under trade secrets. Again, it undermines due process, which we have looked at in the case of Loomis. I earlier discussed the case of Loomis and Compass. So when the decision was reached by the judge, he was unable to challenge that decision because he did not understand how the algorithm works. So it undermines fairness and transparency. So these are some of the effects we have when we use machine learning algorithms that are in essence maybe biased and opaque. Next slide, please.
Okay, so what I would like to do now is take you to two case studies to really bring home some of the things that we're talking about, to move it from a theoretical thing to something that's actually a real life. There's a study in 2016 by Ang Nguyen and a few of our colleagues, and it focused on algorithms used in the USA criminal justice system that was used by judges to predict risk assessment for criminal sentencing. And that piece of software that was developed by a for-profit company called Northpoint and was among the most widely used assessment tools in the US. And they found out after analyzing 7,000 scores for 7,000 people in a time frame between 2014 and 2016 that the algorithms were very unreliable in terms of forecasting violent crime. In fact, it was only 20% accurate. But also they found something very disturbing in terms of the fact that the algorithms were likely to falsely flag Black defendants as future criminals and wrongly label them this way almost twice as the rate as white defendants. And also that white defendants were mislabeled as low risk more often than Black defendants. And just to bring home some of these are photos that are published in the study, and the study is available worldwide, so it is in the public domain. We see things like, for example, here, where there is a risk assessment for one person of 3 compared to the risk of 8 for another person. Now, if we look at the actual record of these two people here, we see that the gentleman on the left has prior offenses of 2 robberies, 1 attempted armed robbery, and a subsequent offense of 1 grand theft. And the lady on the right has prior offenses of 4 juvenile misdemeanors, and there are no subsequent offenses, but she is classified as 8 versus 3. Here's another example where we have one gentleman having a risk assessment of 3, and another gentleman of 10. But let us look at the actual record. The gentleman on the left, he has 1 attempted burglary, subsequent offenses, 3 drug possessions. The gentleman on the right, he has a prior offense of only resisting arrest without violence, and he has no subsequent offenses. Yet still, his risk of offending is placed at 10 compared to 3. And you see the same thing again happening in another case here. One gentleman, risk 1 compared to 6. The gentleman with 1 has 3 driving under the influence of offenses, 1 battery offense, 1 domestic violence battery. And the lady to the right has 2 misdemeanors and no subsequent offenses. Again, we see the last case here. One gentleman, 3 versus 6. The gentleman with risk of 3 has 1 domestic violence aggravated assault, 1 grand theft, 1 petty theft, 1 drug trafficking offense, and a grand theft offense. And the gentleman on the right has 1 petty theft offense and no subsequent offenses. So this is real data that really brings home some of the issues that we have just talked about. The question then is, what is happening here? If we look at the photographs, we see something obvious, that the people who are at a higher risk seem to be ethnic minority people compared to the other people. And the question then is, what's the explanation for that? And the study went deeper and said, well, would the disparity, the results between Black and white defendants, be explained by defendants' prior crimes or the types of crimes they were arrested for? And the study said, no, that was not the case. And even when there was a statistical test to isolate the effect of race from criminal history and recidivism, as well as the defendant's age and gender, we still found that Black defendants were still 77% more likely to be pegged as a higher risk of committing a future violent crime and 45% more likely to be predicted to commit a crime of any kind in the future. So then there was a little investigation into, well, what are these algorithms actually doing? The study looked further and found that the crime formula was based on 137 questions. Very, very importantly, no question asked about the race of the particular person, but it included certain factors like educational levels, whether the defendant had a job, whether the parents were previously in jail, whether the friends or acquaintances were doing illegal drugs, whether the frequency of fights they were involved in, etc., etc. And what we see is that this data, socially constructed data, seems to be very, very consistent with previous criminology theories like strain theory, disorganization theory, and situational action theory, which all point to the fact that poverty, social deprivation, etc., seem to be an indicator of criminal activity. Now, you would say this is in the US, this is not happening in the UK, but we have a report by State Watch from last year, 2025, which looks at the offender assessment system in the UK. And it has been used since 2001 to predict the risk of reoffending of thousands of people. In fact, they compute that we use this about for 1,300 people per day. And that is used in determining bail, sentencing, which prison someone is allocated to, whether the person has access to education and rehabilitation programs, etc. But let's look at what data is this system actually taking in. And you see here lots of data based on accommodation, education, relationships, lifestyle, drug misuse, alcohol misuse, thinking and behavior, attitudes. Again, we do not see race being put here. But definitely then, when you look at the statistics in terms of the output of this system, we see an official evaluation found discrepancies based on gender, age, and ethnicity. And of course, you see a lower predictive validity for people who are radicalized than white people, and especially so for Black and mixed race people. And among all offenders, the actual proven reoffending was significantly below the predicted rate. What they found also is that minorities reported an inaccurate or false information were being entered into the system about them. For example, people assumed that certain people were part of a gang, and it was just put in the system as gang affiliated. And of course, the authors said that there's a suspect that there was bias, there was discrimination. It could have been carelessness, or it could have been insufficient training of the people inputting data into the systems. The report also said that, a lot of these are based on structural racism and systematic bias. These scores really reflect that, either directly or indirectly. Because, for example, you can have biased policing, over surveillance of certain communities based on, for example, socioeconomic status, poverty, ethnicity. And of course, that skews the data that is being put into the systems. But these have really impacts on people's lives, because the higher the risk score is, the harsher the decisions that are being made on sentencing, bail, categorization, and release of people. And these concerns have been put to the Home Office and other bodies. However, these systems are still being used right now in the criminal justice system in the UK. And of course, we have a new system that's going to replace this system this year. But the issues of discrimination and bias have not been addressed in the new system. And in fact, it may be impossible to address, because when we talked about the proxies of data, that the data fed into the systems are compromised in a way by historical injustices. So I will let my other colleague, Uchenna, come in to close the session. Uchenna?
So having looked at some of the issues and the study, having looked at some of the studies we identified, we did raise certain concerns. One of which is that judges are usually unable to understand the rationale behind algorithmic decision, given the fact that these systems are made of complex neural networks, which are difficult to understand even by the developers themselves. Again, we also did realize that judges increasingly rely on this system, for instance, the case of Compass, whenever they're making decisions. Again, it is difficult to contest this decision because we do not know how some of these decisions are reached, especially because the algorithms are opaque. So we don't understand how it was reached. We don't understand some of the data that are being imputed or how they were curated in the first place. Beyond being opaque, which has to challenge the transparency of these algorithms, we also looked at the issue of bias, which does have an effect on fundamental human rights, particularly the right to liberty. This does erode constitutional and ethical foundations of adjudication, lack of fairness, and contestability. Next slide. So, premised on these challenges, we did raise some solutions, one of which includes ensuring that AI-assisted outcomes remain contestable and reviewable. Again, we have identified that the use of interpretable models for high-risk AI systems should be used in critical domains and ensure explainability of the systems. We want systems that are being deployed in this type of facets, for instance, especially criminal justice, to be very explainable, to be interpretable models. When I mean interpretable models, we're referring to models which are developed of techniques that are easy to explain. For instance, your decisional trees or your random forest. Again, we prefer that transparency be mandated to preserve fairness and accountability. If we understand how these decisions, not just the how, but the why certain decisions or recommendations are made by the algorithm, then we can ensure and preserve fairness and accountability of a process. Mandate that cost decision must be independent of the AI system's recommendation. For instance, in the Compass case, which we looked at earlier, we are not, like I said, we are not certain whether the decision of the court was independent of the risk assessment of Compass, because the decision came after the assessment of Compass, and the judge did rely on it. However, it would be better for some of the decisions of the court to be independent of what the system says, which is the court should go ahead and make its decision before it looks at what the algorithmic assessments are. So the algorithmic assessments, if they are in line with the decision of the court, then it could be to support the decision of the court. Mandating judicial training and awareness regarding AI systems. We know that there are already some of judicial training and use of AI systems in criminal justice are ongoing, but we're advocating that there should be more of these judicial trainings on how the system should be used in a very responsible way, where the judges do not solely rely on these systems, but look at this system as an aid to support decision making. Also mandating regular auditing of these systems and identify problems and access to predictive validity. So these are some of the solutions we have come up from our studies, and we feel that these solutions go a long way to solving some of the challenges revolving around opacity and bias in the use of machine learning algorithms. Thank you very much.
Okay, this is some of the references, and we're happy to take any questions. And we hope this was informative and useful. Thank you.